So you're charged with unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine.
17 years old, holding a Glock 19, facing adult-level charges. This is where law and morality collide. Should protecting your family with a gun outweigh being underage and unlicensed?
On February 5th, 2025, the officer responded to a suspicious person with a weapon on 5900 Gulf Freeway. The officer made contact with the defendant, who was 17 years old. The defendant advised he was inside Jack in a Box while brothers were selling waters outside. The defendant saw a male rushing at his brothers with a knife, pulled out his gun, and pointed it at the male while telling his brothers to run. The officer performed a search on the defendant, locating a 9mm Glock 19, and the defendant advised he bought the gun from a friend for $150.
I mean,
Yes, Judge. In this case, the officer was going off the fact that he performed the search because he indicated there was a firearm. So
he's going to the defense of others.
yes, Judge.
It's another person.
And it's just the way this is pled is because he's underage. He's below the age of 21. That's the way it's pled, Your Honor.
You hear this?
Notice how the judge shifts focus. He's less concerned about the gun law and more about the young man's intent, protecting his brothers. That's a subtle but powerful pivot in legal reasoning.
Hold on, I'm gonna go yell at somebody. Hold on. Don't know what's going on. Hi, Judge. Is this young man charged with unlawful carrying of possession for being under 21?
Correct.
Hold on, I've got a kit. Here's the GPS
But I'm
memo.
more concerned about the defense of others. Did you hear it? I mean,
No, hold on.
hold on a second.
Here's
Wait a minute.
GPS.
Let me give you a lawyer, Mr.
Yeah. Oh, I volunteer. I volunteer representation. Yeah,
Give me a record, can you fill that out, please?
I will do that. But here's a GPS memo saying that it's
Hold on a second.
unconstitutional.
You know, representative gentleman?
Oh, hell yes. Here's the Fifth Circuit saying that it's unconstitutional. Here is the United States District Court, Northern District, saying it's unconstitutional. Here's a motion to quash information. I'll just cross out the name.
Great job.
Yeah, I had to get in this fight yesterday and I'm teed up.
Here you go, Mr. Tito.
Thank you.
Judge.
I was
is there
gonna,
a PC?
yeah, look, you gotta be very careful. You know, God forbid something happens.
This is a classic life lesson moment. The judge is hammering home that one wrong decision, even made to protect loved ones, can spiral into a lifelong consequence. Do you agree with his warning?
Where you really dig yourself a hole. I'm going to find no probable cause, but really, you have to be very careful. You know, sometimes you make a decision in life and it can really have consequences. All right. You know what that means, right? Are you in school? It all starts with school, man. You got to get back into school. This is not a good way to go through life at 7. The more schooling you have, the more money you're going to make. Knowledge is power, my friend. Do it. Make something. Make me proud. Please. That case is going to get dismissed. So you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor.
Here's the twist. The defendant admits drinking, but the field tests don't back up intoxication. Legally, that's shaky ground for prosecution. Ever wonder how much discretion officers really have in these moments?
Officers were dispatched to a Holiday Inn in Harris County, Texas, in response to a disturbance. The caller reported that 2 white males left the property, one in an F-150 and one in a Mitsubishi. When the officer arrived, he observed a Mitsubishi which matched the description given in the parking lot, headed toward the nearby road. The officer initiated a traffic stop and made contact with the driver, the defendant. Officer asked the defendant if he was involved in a physical disturbance, and the defendant stated yes, that him and another individual got into a physical fight, and that he got into his car to separate himself and calm down. The defendant stated he was headed toward a gas station when he was stopped by the officer. While speaking to the defendant, the officer observed an odor of alcoholic beverage, glossy eyes, and slurred speech. The defendant admitted to drinking 2 beers, and standard field sobriety tests were conducted. A 6 out of 6 on the HGN, a 0 out of 8 on the walk and turn, a 0 out of 4 on the one leg stand. The DIC was read and the defendant consented to a breath test. The results were a .103 and a .113.
Judge, I'm going to say no probable cause here because.
What's he doing wrong? He's like trying to get away from him. He's like doing the right thing. You know?
And probable cause doesn't exist. He's 0 for 6 on the walk and turn, 0 and 6 on the one-leg stand. There is no law in Texas that a person cannot drink. Just because he smelled alcohol does not mean the person is intoxicated.
Do we have anything that he's doing, you know? Tell me what led them to him?
Yes, sir. So what led to the investigation was a caller who reported the disturbance. The officer arrived and he observed a car which matched the description that the
So
caller
that would be
gave.
like me calling and saying, hey, this guy did this over there. The cops go, no. I mean, theoretically, would be anyone could make a phone call, make an allegation, cops go boom and just stop, do whatever they want without, no probable cause.
Thank you, Judge.
Be careful, man. There's a lot of haters out there. Don't let them get to you, you know? Life's too short, all right? All right, good luck. So you're charged with terroristic threat. You're facing up to 6 months in jail and or a $2,000 fine.
On August 1st, 2024, the officer was dispatched to a disturbance call, and upon arrival, the complainant and security staff stated that the defendant made threats to kill everyone, broke 2 hospital monitors, and was acting aggressive towards the medical staff. The complainant stated the medical staff became scared since the defendant stated, "I will kill you all." The complainant stated she was scared for her life since she did not know what the defendant would do next at that moment.
That doesn't sound right, because I didn't do that.
Words matter. Saying, "I'll kill you all" inside a hospital, even if not directed at one person, instantly escalates to a terroristic threat charge. But should the law treat reckless words the same as concrete threats?
Give you a lawyer and we can go through this with the lawyer. So did he direct it at a person? Is he directing at the entire world? What?
The statement was only made that "I will kill you all." And it says the complainant stated the medical staff became scared, and the statement was that "I will kill you all." That's all we have from the DMs, Your Honor. And then furthermore, the complainant did state she was the only one at the hospital at the time of the officer's arrival, since the rest of the medical staff had gone through a shift change and she was the only one there. So it's not exactly clear who was there when the statement was made. He just said, "I will kill you all."
All right, so who's it directed to? Just,
I don't even know if that happened.
The DMs does state that the defendant started to act aggressive towards the medical staff.
and
So
I think that's why she was scared, right?
it appears that it could follow on saying the defendant was, the complainant said she was scared and the medical staff was scared since he stated, "I will kill you all." So it appears that it was directed towards the medical staff as he was acting aggressive towards the medical staff.
It appears.
Because there's just two
A
distinct,
hunch.
sentences, Your Honor, where he acted aggressive towards the medical staff and the complainant stated the medical staff became scared since the defendant stated, "I will kill you all."
I thought I only did time for that too.
Mr. Mickish, I'm going to find that there's no probable cause to go forward with your case, but you need to be careful.
So,
Scaring people can kind of hurt them. You know what I mean?
Your Honor, I don't,
Look, don't. Mr. Mickish, patience goes a long way.
Yeah.
You know, when you get upset and when you lose control, that's why we have so many people in jail, because they lose control, they do whatever they want to do, and they don't think, if I do this, what's going to happen? If I say this, what's going to happen? Be careful, all right? All right, just hang tight for me in the back. What's his name? Watkins. Mr. Watkins, did you just get out of jail? Where did you think you were going today? To the beach?
No, sir. No, storage. They actually locked it from me, and that's we're transitioning from moving, so I didn't have access to any of my clothes.
Please don't come in clothes. It's very disrespectful. Okay? All right. In shorts, I mean, you're in shorts.
I literally had this on for the left.
Mr. Watkins, you're charged with evading arrest or detention. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and any interviews. If you cannot afford a lawyer will be appointed to represent you. Okay.
But this officer was the check by unit in uniform for a stolen vehicle call and arrived first at the scene.
Bless you.
Suspect approached the vehicle to verify the license plate while the defendant Watkins was outside the vehicle. Witness officer confirmed the vehicle and told the defendant Watkins to turn around and put his hands behind his back. Witness officer stated that the defendant Watkins started to walk away from the vehicle, ignoring all his commands. Witness officer stated that he tried to grab the defendant Watkins by the arm and the suspect pulled away and kept walking. Witness officer stated he again told the defendant Watkins to stop walking away, but he refused to stop. Witness officer stated that the suspect walked an estimate of approximately 100 yards and stopped because he saw the other unit arrive at the scene.
What?
Said that he began to walk away, what he's saying basically, and he was continuing to walk about 100 yards, but another officer arrived.
What was he doing wrong?
Walking away from police isn't exactly sprinting off in a getaway car, but it still lands as evading arrest. The judge sees through it though, calling out weak charges when they don't hold up. This is legal chess in real time.
This was a stop for a stolen vehicle.
Right.
That he was outside. Apparently looks like.
But was he inside the vehicle at any time? Watkins.
I'll check it out, Judge.
Was he?
The license plate, that was via the license plate. He was outside the vehicle, doesn't allege that he was in the vehicle, just said he was outside the vehicle.
Was he standing while black? You know, I mean.
The officer doesn't know how far away this individual was from the vehicle, life, value, person of interest, but
Forget it. Forget it. I'll find no probable cause in your case. Be careful. You know, when you get into a pissing match with an officer, who's going to win? Right? Not only that, when you hang with dogs, you get fleas. So be careful who you hang out with. All right. Just go ahead and take a seat for me. We'll be back with you here momentarily. Good morning, Mr. Sarmiento.
Ese es señor Sarmiento.
You
Bien, señor Sarmiento.
were charged with criminal trespass. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney appointed if you cannot afford one.
Yes, Judge.
We're to go slow.
Yes, Judge. On January 5th, 2025, the officer became aware of a stolen vehicle via a flock alert. The flock alert was for a listed stolen blue Hyundai. The officer checked the vehicle's license plate and observed the vehicle stolen as of December 21st, 2024. The officer observed the vehicle turning northbound onto East Tex Freeway, taking the ramp heading north on East Tex Freeway, and ran the license plate, confirming the vehicle to be stolen. A traffic stop was initiated. The officer announced themselves as HPD while giving command to turn off the vehicle and place hands out of the vehicle. The defendant, the front passenger, was the last to exit the vehicle, and the officer made contact with the complainant, and the complainant stated he did not know the defendant, did not give the defendant authorization to operate the vehicle.
What?
So they found the stolen vehicle, Your Honor.
How does he know that it was stolen?
In Your Honor, there's no need for him to know this vehicle. There's no requirement he knows, only that he's in the vehicle without permission from the owner. And the owner said he does not have.
How does he even know that the person driving stole the car?
Well, he doesn't know the defendant. He didn't say he knows he stole it. He just didn't know him, did not get
So
permission.
you're telling me that he's in a car, he doesn't know the driver? And
Right, the complainant just said that in regard, he did not know the defendant, did not give.
I understand that. I get that,
Yes.
but so he's he's a passenger in a car and they charge him with criminal trespass. And in the DIMS, it says that he doesn't even know the driver. So how would he even know that the car is stolen? How do they know each other? I'm beside myself. I don't. When a criminal trespass requires some kind of like notice that, hey man, you know,
Un aviso.
So the trespass was, the driver driving into the area and he was this kind of.
he's the passenger, right? I would assume that the driver got charged with UUMV.
Let me see what he got charged with.
Tuvo un caso.
If you tell me no, I'm gonna lose it. Really?
Yes, Judge, UMB.
Okay. But the problem is that like, how would he know that the car's stolen? Right? You got to give me something that it's a specific intent crime. You have to, you know, there's got to, in my opinion, you've got to somehow know that the car is stolen. And
Your Honor, further, I guess to get to that, he was in a relationship with the defendant who was in the vehicle, and there were signs of damage to the vehicle that the officer articulated, saying that there was. One moment.
Un momento.
a scratch on the hood.
Signs of theft that would lead a reasonable and prudent person to believe the vehicle was stolen, as the steering column was broken in a manner that only a screwdriver could turn the vehicle on, and the screwdriver was tagged into the evidence. So there was damage from a screwdriver in the vehicle indicating that it was stolen, and this defendant was in a relationship with the driver of the vehicle. And then furthermore.
Did you just tell me that they didn't know each other?
No, the complainant does not know the defendant.
Oh, okay. I thought you also said that the driver and.
No, Your Honor, and it may be misunderstanding because of me, but it's the complainant saying he does not know this defendant and did not give permission to the defendant to operate the vehicle.
So there is enough there that a reasonable person would believe
That
he's in a stolen car.
yes.
So the steering column, was it?
Was broken, and the officer said that in a manner only a screwdriver could turn the vehicle on.
Un desarmador podía apagar el vehículo.
See, I don't know, because when I was young and dumb and 17, and, my friend had a CJ7, you ever been in those Jeeps that are just jalopy Jeeps, right?
Yes,
They
yes.
always broke down. They always had a problem. We always, Jimmy rigged it as well,
In this case, Judge, I believe there would be enough for PC because we have a vehicle with evidence of breaking into the vehicle with that damaged steering column.
I've been in vehicles like that before.
And we furthermore have a complainant saying he doesn't know the defendant in the vehicle.
That no difference to me.
That goes to the element of for the criminal trespass, it goes to with knowledge that it was,
Nah, I'm not, no, I'm sorry. I'm going to find no probable cause. I'm sorry.
Que no hay razón probatoria.
Be careful. When you hang with dogs, you get fleas. I don't know what your status is in this world, if you're in this country with permission. But if you go to jail and you're not in this country with permission and you spend any kind of 4+ hours in there, immigration will put a detainer on you and you will be stuck like Chuck in there until you get shipped to immigration. So live like a halo, especially if you're not well documented in this country. Go ahead, take a seat for me, sir.
Great, Judge, the next